Okay. In an adoption proceeding from an authorized agency, if the child is less than 18, the child must have resided with the adoptive parents at least 3 months before the order of adoption is made.
Who may adopt a child? 7 of them, just so you know.
All right, 7. So 1, an adult unmarried person. 2, an adult married couple together. Any 2 adult unmarried intimate partners.
Yeah.
An adult married person who is living separate and apart from her spouse pursuant to a judgment of separation for at least 3 years. An adult married person who is living separate and apart from her spouse pursuant to a written agreement of separation for at least 3 years. An adult married person who has been living separate and apart from her spouse for at least 3 years prior to commencing an adoption proceeding. Adult or minor married couple together may adopt a child of either of them born in or out of wedlock, and an adult or minor spouse may adopt such a child of the other spouse.
Yes, that's how they happen. Who may adopt? 1, an adult unmarried person. 2, an adult married couple together. 3, 2 unmarried adult intimate partners. 4, a married person legally separated for at least 3 years, and that would be like with the judgment or the agreement. 5, a married person living apart from their spouse for at least 3 years. I think that's abandonment. 6, an adult or minor husband and his adult or minor wife may adopt a child of either one of them, born in or out of wedlock. 7, an adult or minor husband and his adult or minor wife may adopt a child of either of them. Whose consent is required? 1, consent to adoption is required if, and notice must be given to, A, the adoptive child, if over 14, unless the judge or the surrogate dispenses with such consent. B, the parents or surviving parent, whether adult or infant of the child conceived or born in wedlock. The mother, adult, or infant of a child born out of wedlock. D, the father, adult, or infant of a child born out of wedlock and placed with the adoptive parents for more than 6 months after birth, but only if the father maintains contact with the child as per this section.
Oh my God.
Oh God. E, the father, adult, or infant of a child born out of wedlock under 6 months when placed for adoption, but only if, now there's 3 things. 1, the father lived with the mother for 6 months prior to placement of the child. 2, the father openly holds himself out to be the father. Or 3, the father paid reasonable expenses for pregnancy and the child. And F, any other person or authorized agency having lawful custody of the adoptive child. This is fucking crazy.
Yeah.
Okay. I'm just gonna do this one more thing, and then I think we should just do the question.
Yeah. Okay.
Okay. Consent to adopt is not required of a parent or person having custody who evidences. What the fuck is that word? Evidences?
Oh, like shows evidence by their actions. They're showing the evidence. Like their actions is the evidence, I guess. I know what it means. I just can't explain it for some reason.
Okay. All right, whatever. Consent to adopt is not required of a parent or person having custody if A, who evidences intent to forego parental rights and fails for 6 months to communicate with child or person having legal custody. B, who surrendered the child to authorized agency as per 383C or 384 of the Social Services Law. C, for whose child a guardian was appointed as per 384B of the Social Services Law. D, who is mentally ill or has intellectual disability and unable to provide care of the child as per 384B of the Social Services Law. And E, who has executed irrevocable instrument denying paternity of the child.
Okay.
Okay. Now, do you want to just do
the questions? Yeah, let's do the questions.
It's like way too much here. Okay. True or false? An adult or minor husband and his adult or minor wife may adopt child of either of them born in or out of wedlock.
True.
True. It is unlawful to preclude a prospective adoptive parent because of poor health or limited life expectancy. I don't like this. But
That's false. It's false. Or subsection or no?
no, they don't give anything.
Oh my god, because this 109 is like the whole thing.
Hold on.
All right, you could read the next one and...
Oh, I have it here. It is unlawful to preclude prospective adoptive parents because of cancer or any other disease. However, a prospective applicant may be rejected on a basis of poor health or limited life expectancy.
Yeah, so that thing that you read is false. Because they can be rejected based on that.
Yes. In an adoption proceeding of a child born out of wedlock, notice does not need have to be given to a person convicted of blank when the child was conceived as a result.
It's rape first and second, course of sexual conduct against a child first degree, predatory sexual assault, and predatory sexual assault against child.
Yes.
I mean, how could you predatorily sexually assault an adult? Like, I don't get it.
I don't know. It makes no sense. Okay. Notice shall be given at least blank days prior to the proceeding via delivery of a copy of a petition and notice of petition. So the notice of petition.
The notice of petition shall be given 20 days.
Yes, 20 days.
Okay.
A notice shall contain a statement that failure to appear constitutes denial of interest in the child and may result without further notice in adoption or other custody disposition.
That's true.
Yes, true. Generally, in an adoption proceeding from an authorized agency, parents and adoptive child may or must appear before the judge or surrogate.
That's true, yes.
Yes, they must appear. True or false, the petition must be verified.
Yes.
Yes. In an adoption proceeding from an authorized agency, if the child is less than 18, the child must have resided with the adoptive parents at least blank before order of adoption is made.
3 months.
Yes, 3 months.
This is the 3 months. Okay. This is when they have to live with 3 months.
Yeah, now I'm going to do the other one. Generally, if the child is less than 18, the court shall not make an order of adoption until blank months after the court received petition to adopt.
3 months.
Yes. Adoption proceeding is deemed filed upon receipt by the clerk of all required documents together with blank from the petitioner's attorney.
It's the affidavit of readiness.
Yes.
Are your windshield wipers on?
Oh my God, you can hear that?
Yeah. That's better.
I don't even know why I have it on. That's so funny. As far as is practicable, the judge must give a custody only to the person of the same religious faith as that of the adoptive child.
That's true.
Before adoption records are sealed, the court order for a certified copy may be granted upon blank application.
That the written report of the investigation, together with all the papers pertaining to the adoption, shall be kept by the judge or surrogate as a permanent record of his court, and such papers must be sealed by him and withheld from inspection. No certified copy of the order of adoption shall issue unless authorized by court order, except that certified copies may issue to the agency or agencies in the proceeding prior to the sealing of the papers.
Before the record is sealed, such order may be granted upon written ex parte application on good cause shown and upon such conditions as the court may impose. After the record is sealed, Such order may be granted only upon notice, as hereinafter provided for disclosure or access and inspection of records. So it says, after the record is sealed, such order may only be granted upon notice, as hereinafter provided for disclosure or access and inspection of records. The clerk, upon request of a person or agency entitled, shall issue certificates of adoption which shall contain only the new name of the child and the date and place of the birth of the child, the name of the adoptive parent, and the date when and the court where the adoption was granted, which certificate as to the facts recited shall therein have the same force and effect as a certified copy of an order of adoption. Now here, this is where it goes into, I think, what you're asking. No person, including the attorney for the, oh no, this is different. This is no order for disclosure or access shall be granted except upon good cause shown and on due notice to the adoptive parents and to such additional persons as the court may direct. Oh, here it is. Such order may be granted upon written ex parte application on good cause shown and such conditions the court may impose. That was before the record is sealed, right?
Yes.
So then it goes into after the record is sealed.
Yes.
Such order may be granted only upon notice as provided for disclosure, access, and inspection of records. The clerk, upon request of a person or agency entitled thereto, shall issue certificates of adoption, which shall contain only the new name of the child and the date and place of the birth of the child.
Now, does it say, the next question is, an adoption certificate has the same force and effect as a certified copy of an order of adoption?
They tell you that the clerk issues it.
No, and that's important.
That's important. It says the clerk, upon request of a person or agency entitled thereto. So that means the person entitled to request the certificate shall issue certificates of adoption which shall contain only the new name of the child, the date and place of the birth, the name of the adoptive parents, and the date when and the court where the adoption was granted. So that is a really easy question to ask because it's a list.
Yeah.
And it's the clerk issues it.
Can you repeat that again? Like just
Yes.
the whole...
Absolutely.
Okay.
Okay, so this is after the record is sealed. Such order may be granted only upon notice, as hereinafter provided for disclosure or access and inspection of records. Period. The clerk, upon request of a person or agency entitled thereto. So let me read that without all the clerk, upon request, shall issue certificates of adoption which shall contain 1. The new name of the child. 2. The date of the birth. 3. The place of the birth. 4. The name of the adoptive parents. 5. The date when the adoption was granted. And 6. The court where the adoption was granted. So it's only those 6 things that go in it. Which certificate as to the facts recited therein shall have the same force and effect as a certified copy of an order of adoption. So that's telling me that the order of adoption has more stuff in it. It's about sealing. It says no person, including the attorney for the adoptive parents, shall disclose the surname of the child, directly or indirectly, to the adoptive parents, except upon order of the court. No person shall be allowed access to such sealed records, an order and any index thereof, except upon order of a judge or surrogate that granted the order of adoption, or a justice of the Supreme Court. Order of a judge or surrogate that granted the order of adoption, or a justice of the Supreme Court.
Oh, shit. Okay.
I could tell you when I worked in surrogates, the adoption files were kept in a separate room. You couldn't go near them. Adoption clerk would pull their own files.
So that's really good to know. I think they're like about stealing right now. They're like OCA. I don't know.
Yeah, probably because people aren't doing it right or something.
Yeah, and who knows if they had a lawsuit. An order of adoption may be opened, vacated, or set aside by a judge or surrogate by whom the order was made for fraud, newly discovered evidence, or
other sufficient cause.
Yes.
Serious physical or mental illness is prima facie evidence of good cause.
Yes, put that in there because no other place really says that.
Yeah.
Okay. private placement adoption proceeding venue is private placement proceeding.
Okay, so private.
You're close. Well, yeah, you're like almost there. It says shall be instituted in the county where the adoptive parents reside, or if the adoptive parents do not reside in New York State, in the county where the adoptive child resides.
Because I wasn't really close.
Oh, I thought you were. Okay.
I wasn't because I said them in the wrong order.
Okay. To me, that's close. All right. Okay, so if this is a private placement adoption, venue is where the shall be instituted in the county where the adoptive parents reside, or if the adoptive parents do not reside in New York State, in the county where the adoptive child resides. So if the adoptive parents like live somewhere in fucking Georgia. So the adoptive parents are in Georgia, but the kid was like left somewhere in the Bronx somewhere, and there's nowhere to go. Then it would the adoption for the private person would be where the child resides in the Bronx, but that's only for the private placement. One.
Would you like me to read the other one? This is special provisions relating to adoption from authorized agencies. An authorized agency may consent to the adoption of a minor when guardianship has been transferred to such agency. New York City, an authorized agency may submit a written request to a social services district when the child's parents are both dead, or one parent is not entitled to notice and the other parent is dead, to whose care and custody has been transferred to a social services official, and who has been placed by the social services official with the authorized agency. If the request is not disapproved by the social services agency within 60 days after submission, it shall be deemed approved, and the authorized agency may give all necessary consent to the adoption. Then it goes on to talk about where the venue shall be. So if the adoption petition is filed pursuant to 112 of this article, or 383-C of the Social Services Law, or 384B, the petition shall be filed in the county where the termination of parental rights proceeding or the judicial surrender, as applicable, is pending, and shall be assigned whenever practicable to the same judge. So the first provision says if the child has been surrendered or lost custody pursuant to the Social Services Law, the petition shall be filed in the county where the termination of parental rights proceeding or judicial surrender is pending and shall be assigned whenever practicable to the same judge. Then 2 says, in any other situation, so in any other agency adoption proceeding, the petition shall be filed in the same court and wherever practicable shall be assigned to the same judge of the county in which the parental rights have been terminated, a judicial surrender had been approved, or the most recent proceeding under Article 10 or 10-A or Section 358A had been heard, whichever occurred last, or in the county where the adoptive parents reside, or if the parents reside in Georgia, in the county where such agency has its principal office. Again, this is saying that number 1, you go to where the court had the last proceeding. Number 2, you go to the county where the adoptive parents reside, but if they do not live in New York, it's where the authorized agency has its principal office. It does not say where the child resides.
Okay, good.
And then it says, these procedures are applicable in cases where the child has been under the jurisdiction of a family court, but where the adoption petition is filed in a court other than the court that presided over the termination of parental rights, surrender, or Article 10 proceeding, or 358A, whichever occurred last. And let me just make sure it didn't say anything else that might be important. Okay, so go ahead.
Unless waived by the court in a private adoption, adoptive parents must be certified as qualified adoptive parents. True or false?
Yeah.
Yeah, true. Stupid. In private placement adoption, the prohibition of the surname of the child appearing on papers does or does not apply.
Oh, what's the answer?
It does not apply.
Oh, fuck.
Private placement adoption. The prohibition of the surname of the child appearing on papers does not apply. If a mother is giving her child up for adoption willingly, like if she's 16 years old or something, that's what I'm thinking.
Yeah.
If, like, 18-year-old and she's like, I'm giving up my kid for adoption when I have the baby, I don't think that the last name or whatever like matters. I think that's private placement.
Okay. All right, so this is only for private placement because in the other one, they can't have it there. They can't have the surname.
An authorized agency, I think that's when like the child gets given up, like they lose rights or they die or
Or the parents died, yeah. Okay. Okay.
I think I'm right, but I'm not 100% sure because I know nothing about adoption.
All right, well, hopefully we'll just remember that the surname thing does not apply to private placement adoption.
Yeah. Consent to adoption executed by a person in foster care shall only be executed before a judge of foster care. Foster care. What?
Family court.
Yes, family court.
It has to be in the family court.
Yes, F&F, family court, foster care, family court.
Oh, let me look. This is private placement adoption. So why is the kid in foster care?
Oh my God! See, I'm fucking wrong. Private placement, then. Is private placement then like you just don't go through an agency?
But I thought you have to go through an agency. Understanding how the kid is in foster care.
I don't know. I don't know. Do you know I don't even know anybody who works over there. Oh, I looked up what private placement adoption is, and this is what I got. Private placement adoption refers to children who do not come into the care of a licensed adoption agency or the state. Wait, but isn't foster care the state? Oh, fuck, I don't know. Usually these types of adoptions begin with private agreements between parties and may involve family members or step-parents. So I think that's why, because you could be in foster care, but you can be a relative as a foster care.
I'm going to look for where it says the family court only, though.
Okay.
While we're waiting.
Yeah, well,
because I'm not seeing where it says the consent can be executed through a judge or surrogate. But I must not be in the right section. I don't know. Oh, wait, I found it. Very beginning of the article. And it says, a duly executed and authorized and acknowledged consent. So a duly executed and acknowledged consent to a private placement adoption shall state that no action or proceeding may be maintained by the consenting parent for the custody of the child to be adopted, except as provided in this section. Notwithstanding any other section of law, a consent to adoption executed by a person who is in foster care shall only be executed by a judge of the family court, before a judge of the family court. So, so it says, a consent to adoption executed by a person who is in... Oh, so this is a minor, I think, who's in foster care.
Oh, okay.
And has a baby.
Oh, shit, okay.
That's what I think this is talking... Not the kid is in foster care.
Oh, okay.
Because let me read it to you, and you tell me if you think I'm interpreting this correctly.
Okay.
Notwithstanding any provision of law, a consent to adoption executed by a person who is in foster care shall only be executed before the family court.
Oh, shit, I think you're right.
I think that's what it says.
I think you're right.
Let me read it again. Notwithstanding any other section of law, a consent to adoption executed by a person who is in foster care shall only be executed before a family court.
Yes, I think you're actually right. Yes, I think you're right.
Because literally, then the entire rest of 115-B is talking about a judge or surrogate.
Yes, I think you're right.
I think that's what it is, because nothing else is talking about only a family court. Everything else is both.
Yeah, I think you're right. Consent to adoption executed by a person in foster care shall only be executed before a judge of,
The family court.
okay, consent to private placement adoption may be executed or acknowledged before any judge or surrogate in New York State and shall state that it is irrevocable. True or false?
It's true.
Yes. See, so now this makes so much more sense. If it's foster care, if they're in foster care, the person's in foster care, then it's family court. But anything else, it's any judge or surrogate in New York State.
Right. It's only if the parent is in the birth parent is in foster care that it has to be family court.
Yes.
Okay.
Okay, so that makes so much more sense now.
Yeah.
Okay. Generally, consent to a private placement adoption not executed or acknowledged before a judge or surrogate becomes irrevocable within how many days after execution of consent?
45 days.
Yes, I fucking forgot that. Shit, okay. Okay. If notice of intent to revoke consent is received by the court, it shall promptly notify the adoptive parent and attorney by blank mail.
It's a certified mail.
Yes. Generally, where physical custody of a child is transferred to adoptive parents, such parents shall, within blank days of taking physical custody, file either a petition for adoption or application for temporary guardianship.
Shit. Is this also...
Like, how am I going to remember this?
Oh, my God. Is this the 10 days?
Yes.
Oh, shit.
Yeah. Okay.
That's really fast.
I know. Generally, where physical custody of a child is transferred to the adoptive parents, such parents shall, within 10 days of taking physical custody, file either a petition for adoption or application for temporary guardianship.
All right, so temporary guardianship, 10 days.
Yeah. Before that made sense.
Wait a minute. I think your fucking notes are wrong.
Why?
It's not 10 days. It's 10 court days.
Fuck. It's 115C.
Yeah, I'm looking at it right now. It says temporary guardianship by adoptive parent. In any case where physical custody of a child is transferred from the child's parent or guardian to another person for the purpose of adoption, and a consent to the adoption has been executed, the adoptive parent shall, within 10 court days of taking physical custody, either file a petition for adoption with a court of competent jurisdiction or file an application for temporary guardianship of the person. That's different.
Yeah, it is different. True or false, a petition for certification shall be denied if the petitioner was convicted of felony, child abuse, neglect, spousal abuse, crime against the child, or crime involving violence.
That's true.
Yeah.
And that's any time. And then the one about the 5 years is like lesser stuff.
The 5 years one. Did I do that one already?
No, I don't think so.
What?
I don't think you did it yet.
Let me see where it is. A petition for certification shall be denied if the petitioner was convicted of a felony within the last 5 years for physical harassment or battery or drug-related offense.
False. It's physical assault, battery, or drug-related offense. Not harassment.
Oh shit, because this says true.
It's physical assault, battery, or drug-related offense.
It's physical assault?
Yeah.
That's wrong. Oh my god, so it's physical assault.
Yeah, not harassment.
Oh shit, alright, because that was, oh my god.
It's a felony, it's a felony conviction within the past 5 years for physical assault, battery, or drugs.
Okay, then we're going over this. Alright, next. Pre-placement investigation shall be made by a blank person.
By a disinterested person.
Yes, disinterested person. Next question. A disinterested person includes a certified social worker, the probation service of the family court, or an
Authorized agency designated by the court.
to conduct pre-placement investigation. Yes.
Yeah, so it's a social worker the probation service or the authorized agency designated by court.
Okay. An order granting certification is valid for a maximum of blank months. This is an order. The order granted.
The order granting, is this the 18 months?
No. Yes, sorry.
Okay.
Yes, 18 months. Okay. Next. Generally, a conditional order of certification, so now the conditional order is valid until replaced by an order of certification or by an order denying the petition, whichever occurs first, but in no event is longer than blank days from the date of the original issuance. Now,
Okay, so I remember this because the regular order is 18 months, and then the conditional order, you take the 1 and the 8 and put a 0 next to it, and then it's 180 days. So it's 18 months and then 180 days.
Yes, perfect.